We're going to be starting with the afternoon session. The first conference is of Professor Carmen Vázquez. She teaches here precisely at the University of Girona, and she has stayed for research in a number of prestigious places in Northwestern University, UNAM, Miami University, a long list. And she also is the author of a number of very important publications, such as From Scientific Proof to Expert Proof Evidence, and a series of publications on scientific evidence and so on. And she is going to be taking the floor right now.
Muy buenas tardes a todos.
Good afternoon, everyone. Once again, welcome to Girona. It really is truly a pleasure for us to have you here with us these 3 days in this conference, for which we have actually worked intensively, and we really hope you will enjoy it. This afternoon, I will be talking about the judicially appointed expert in the case of Spain. This is the title of the presentation, and I will be dealing with 4 fundamental subjects: the preference, traditional preference for court-appointed experts in Roman, Germanic traditional systems, the civil Spanish of the examples of a system that clearly has had a preference for court-appointed experts. Then I'll talk about governmental and jurisdictional activity and the appointment of such experts. And then I'll be talking as well on the impact of some differences that are seen traditionally between court-appointed experts and party experts. My presentation will be rather critical, not only with the figure of the court-appointed expert itself, but also concerning the difference between a court-appointed expert and the party expert, as I will try and develop in the coming minutes. The traditional preference for these court-appointed experts now has traditionally been highlighted in legislation and also in model codes that have been developed sometimes for Latin America or for the Roman Germanic tradition in general. And there is clearly a conceptual concept by which expert is what we call the court-appointed expert. Parties traditionally had the possibility of appointing an expert, but those experts had actually acted as a kind of aid, not really as experts. So then those people could actually see what the court-appointed expert was doing, but they didn't have direct access to the object itself of the expertise. So traditionally, the consideration as well was that any expert, either court-appointed expert or the witness, the expert witness, should be impartial. Even expert witnesses had this duty of being impartial with the judges, and this duty has been established in very generic terms, really very non-specific. So we don't see the clear establishment of what those duties would be beyond, for example, taking into account all the information, either favoring or not favoring the party that actually took this expert witness. There's also been a traditional regulation as causal in the case of witnesses, so the same for one and another, and according to the judge. So the same causes that might lead to not taking on a judge can be used for an expert. That is the general scenario, but of course every legislation, every judicial system has its specificities. But I would say that in general terms, we really could assume that traditionally this has been the legislation regulating this expert evidence in our systems. So this preference has not only been seen or has had an impact on the jurisdiction, on the legislation, but of course on judges themselves. In Spain, for example, we have a number of jurisprudential theses of the Supreme Court itself, in which there is an attribution of greater probatory value to a court-appointed expert, because the main argument is that, well, he or she has been selected in an impartial manner. So as a court-appointed expert is selected in that way, and there is no participation of the parties, well, then the attribution is a priori of greater probatory value on the basis of these jurisprudential criteria. At least in the case of Spain, jurisprudence is not clear either in that direction. There are many criteria regarding this, but we do have the opposed criteria stating that the court-appointed expert doesn't have necessarily greater probatory value, but the jurisprudence exists and it's used. So when empirical studies have been carried out to ask judges about their preferences for one or another type of experts, empirical studies are very clear. For example, the Judiciary Council in 2015, when asked about what would be an opinion of the judges, one of the way in which one might improve the justice administration as regards economic crime or related to corruption, quite a high percentage said that it would be important to have an organ of experts that would work directly for judges without there being any relationship of these experts with the parties. So those would be judicial or official experts. There are other empirical studies that have been published. This is one from 2005, and when judges are asked about the relevance, in this case, this has to do with the economic evidence, and judges are asked about the relevance of this. Well, 73% of the judges say that the expert evidence is very relevant in these cases, but most especially when the expert is a court-appointed expert. 73% of the judges, no less. And then when they are asked, do you think that the expert witness acts usually with the necessary level of independence and authority? Well, a very high percentage say that, well, in few occasions, and many say practically never. So there's always this doubt. There are empirical studies then showing what has been shown, at least in Spain, regarding the fact that the judicial preference goes beyond jurisprudential criteria. And there's a marked trend in that judges prefer court-appointed experts. The scholars of procedural right follow the same line exactly in Spain, but not only in Spain. I would say that in all Europe, or at least in the southern European countries, traditionally in procedural doctrine, there's been a whole discussion on whether the expert, considering that the expert is a court-appointed expert, is in fact a genuine evidence, or is he or she an auxiliary of the judge? Should we consider these court-appointed experts as auxiliaries or assistants of the judge? This controversy led to the Spanish legislate in the year 2000, which was the year of the issue of the civil law, to state explicitly that this expert evidence was genuine evidence and was not assistant of the judge. In all this scenario, the doctrine, but not only the doctrine of Roman Germanic tradition, we can also find many of these references in doctrine of common law in general, there is an identification of three argumental lines in order to attribute or justify that preference, that judicial preference for court-appointed experts and not expert witnesses. One is selection, the selection process that is used in order to select the expert that will be the expert of that case when it's a court-appointed expert or an expert witness. In that selection or recruitment of the expert, they talk about the information given to the expert for he or she to carry out the expert operations. Of course, the information given by the parties can be impartial. The information given by judges will always be complete. Second argument that is put forward to defend court-appointed experts, and not the others, is the financial side of things. Parties pay their experts, whereas official or court-appointed experts are not necessarily paid by the parties. Let me anticipate here that in the Spanish system, the court-appointed expert can in fact eventually be paid by the parties when the parties request that the judge be who appoints the expert. And the last argument has to do with the preparation of lawyers, the way that lawyers prepare their experts, because as it's lawyers who select the expert, in this case, the expert witness, and give the information to this person, they also adequately prepare the expert witness for he or she to favor the case they want to put forward. So these are the three arguments, and then this is the general scenario in which I would say that we operate at different levels and to different degrees and it's what we've been doing up till now in civil law in systems of Roman Germanic tradition. It is true that in recent years, many countries of that Roman Germanic tradition have had deep procedural reforms in which, at least in some of these countries, things have changed and a lot of emphasis has been placed on the expert witness. And in some systems, the court-appointed expert has been actually eliminated. But I insist, this general panorama, is useful only as a call of attention regarding tradition, where do we come from.
El siguiente paso, en la ley de enjuiciamiento.
Next step in the Spanish procedural law. In the year 2000, in this new code, Spanish legislators changed this Roman Germanic tradition, establishing a certain preference for the expert witness. And they stated that when in the process, an expert has to be introduced, it has to be expert witness, and it reduced those situations in which a court-appointed expert could actually work. So basically, when parties don't have financial resources, when the judge activates certain probatory powers, and many other possible situations. And there I include the fact that we have to really clarify this preference, this initial preference of the Spanish legislator, because one of the strongest criticisms that has been addressed to the Spanish legislators regards evidence is that the regulation as to at what time can expert evidence be requested is really very confusing, because there are at least 12 procedural moments in which expert evidence can be requested. Out of those 12 times identified by doctrine, for example, Joan Picot, well, at least in half of those procedural moments, and despite the initial preference of the legislator, at least in 6 of those procedural moments, it has to be if parties request an expert, and that expert will be a court-appointed expert, not an expert witness of the parties. So then the preference, once again, is there. But it can be seen even more clearly maybe in one of the procedural moments in which one can request an expert, and that's very much at the end of the oral sessions when the ruler encounters problems in seeing all the evidence that has been stated during the oral part of the proceedings. And for example, we have this other empirical fragment of information. When judges are asked at what moment in court do they most probably call for a court-appointed expert, they state exactly that when the two expert witnesses of the parties and their conclusions are contradictory with each other, then they appoint a court-appointed expert in order to be able to solve this conflict or this lack of agreement between expert witnesses. Obviously, the judge there has huge power because evidence was put forward already, and the expert witnesses stated whatever already. So there, of course, it's the judge calling on for another court-appointed expert that has information about the case. Yes, something else I would like to mention and highlight for you all is in what I'm going to continue to talk about when I talk about court-appointed experts, I'm not referring to public institutions. That's important. One can establish a difference when we talk about that kind of expertise between public institutions that carry out such expert procedures, but then also experts that circumstantially act as experts in some judicial processes. I think the public institutions, the task of whom is to be experts, have different problems. I mean, sometimes they are financial issues, sometimes it's the staff working in that kind of institutions, and so on. But, of course, all those problems, I think, do merit a different kind of analysis and study. So I won't be talking about public institutions that act as experts, such as forensic medicine. I'll be talking about experts that are experts only circumstantially. So in that scenario, in court-appointed experts, the Supreme Court in Spain, in fact, has established a distinction. That is, how do judges appoint the expert of a case? Well, the Supreme Court said, okay, let us analyze. We have to distinguish governmental activity and jurisdictional activity. Governmental activity would consist then in actually making available to judges the possible experts, who in many Roman Germanic tradition systems means that judges have lists of experts that are ready to give their expertise, or a whole set of different lists with different specialties and disciplines, with every expert according to discipline. Experts that circumstantially could actually be court-appointed experts in a given case, whereas jurisdictional activity, on the other hand, would be the selection of the expert that will act as an expert in the specific case. So let us go, first of all, to governmental activity, the list of experts. There are at least two options and two ways in which this in different legal systems has been organized. How are these lists made? Well, one possibility is open call by judicial powers for any expert who is available and wants to participate or be part of that list or that catalog that eventually will be there available to the judges. There is a second option, and the second option is the one that has been assumed in Spain by the Spanish legislator and all the praxis, and that is the experts themselves are the ones who make those lists. A priori, there seems to be an important difference, of course, between the fact that those lists or catalogs are made by lay people in a kind of process that's totally administrative, in which there is a review of the compliance of the very formal requisites, such as qualifications, years experience, absence of criminal record, and so on. And then other lists carried out by experts where one might expect that the experts would have greater control over who could be part of those lists of possible experts. In the case of Spain, there was a whole, well, there has been, in fact, in recent years, a very intense discussion that didn't get really to be known by everyone because it happened, well, behind stage, so to speak. Initially, the legislator and the many documents issued by the General Council of Judicial Power, that's the governmental organ in Spain, had stated that those lists or catalogs of experts had to be submitted by professional colleges. Professional colleges are public interest institutions in Spain that have the obligation of controlling the way every profession is put into practice. After that, there were a series of problems and associations of experts or groups of experts, private groups that came to the fore, and these professional associations had, well, they worked in disciplines that didn't have university studies behind, so to speak, and these professional associations complained and said, listen to us, judges. We want to participate too as experts, and we have full right to be experts. Many decisions were made on behalf of the Supreme Court, and there was also the influence of some European regulations that this obligation of belonging to a professional college, especially for some professions. what was the impact of this? That the Spanish judiciary power opened the door to any group of experts for them to send their names for this list or catalogue of possible court-appointed experts. An association in Spain can be made on the basis of 3 people. So that means 3 people who come together and associate to make or create an association can decide to every year send an expert list to the judiciary power, so that the judiciary power has this list ready of possible or potential court-appointed experts. And with this change in judicial powers in Spain, in the different organs, better said, well, they started to see that there was the need of managing twice the number of lists of experts that they had been receiving up until then. And they did all sorts of administrative procedures so as to do things in the best way possible. And amongst, well, part of the task meant that they eventually delegated all the governmental tasks to the regional governments in Spain of the different regions. So it's the governments, the regional governments, that now are responsible for managing those lists. Regional governments then, well, the first step is to specify a list of specialties and subspecialties or disciplines. And then it's the experts themselves, or better said, the professional colleges and associations themselves, that introduce the information and give the names and say, well, I should be classified here or there. And here you have an example on the slide. You won't see it very well, but it's an example of the community of Valencia and the community of Catalonia about specialties and subspecialties that the administration considers as a good classification in order to have those expert lists. But how do they get in? What are the controls on behalf of the professional colleges or the associations? How do they make sure that people get in and become members, but complying with what is requested? Well, it depends. It depends really on every association. It depends as well on every college. There is no common regulation. There are some professional colleges that have regulated a special procedure to make sure that all members can eventually become part of this expert list. There are colleges where we don't know whether they have anything, and there are other colleges where there is nothing. Nothing at all. So one exception to this, and it's a public association, is, for example, the Physicians College of Madrid, where each expert that wants to be part of the list has to go to 2 commissions, one a substantive commission assessing the level of knowledge and updated knowledge as a physician, and there is a deontological commission as well there that the physician has to go to, and that possible conflict interests or problems that would make that physician not be able to become a court-appointed expert. But let me insist, it's an exception. It's not the rule. We don't have a common legislation concerning this in order to know what each one of the professional associations and colleges does in order to get these lists ready. We should go to the statutes of every one, or the bylaws of every one of these associations, and see whether they make sure that everybody complies. What criteria do they use? Well, usually formal clauses. There's just one innovation, which is that in professional associations, they have eventually become, and let me tell you, I apologize previously, but they've become machines that issue certifications. So in fact, what the associations do is say, you, Mr. or Mrs. Expert, has a qualification in this or that activity and those studies, but I'm going to give you 2 courses. Courses in which you will acquire the necessary legal expertise to carry out your profession, or sometimes even 6-month courses for you to become whatever, and for you, if you're a lawyer or a physician, you'll become an expert in graphology, for example. So many professional associations have become these certification or qualification issuing machines, and that means that they give many names for the lists of people that eventually could become court-appointed experts. In all this panorama or landscape, at least as regards governmental activity, there is incredible dependence regarding the quality of the experts that are part of these lists. And in fact, well, in every list, we depend really too much, maybe, on the different groups, on the different associations and colleges. And here I think it's very important to remember at least part of the experience in the US as regards expert court-appointed experts and expert witnessing. It's very interesting to read and to know about the experience in the United States of America. Why? Because one of the essential things that we have learned from the experience in the US has been the leap to expert groups. That is, traditionally, we tended to focus in order to value evidence, expert evidence, or concerned about the quality of this expert knowledge, we tried to find out what is said or done by the specific expert of the specific case that we are working on. But we have not turned to see expert communities that are, I mean, it's the communities of experts that can give us, in fact, much of the information that we require about the reliability of methods and techniques that private experts use. But of course, when I talk about the fact that you have to look toward the other side and look toward communities of experts, I don't mean let's just have a look at them, but it means that at least once a year we have to ask for a list of the members that are ready or have the will to be experts. We should ask for something else, not only that. For example, empirical information about the methods and techniques that they are using and they intend to use in these jobs. So it is true that groups of experts could give us much of this information, but they don't solve all the problems of expert evidence, because although it is true that they can give us empirical information about the reliability of methods and techniques that these private experts use, we are always going to need to know and also judicially assess what the expert did in the specific case that we are working on. It's not enough for me to have empirical information about the reliability of the method and the technique of the expert, but rather did he or she apply all this properly in the specific case. So to go to groups of experts, yes, is a step forward, but it doesn't free me from all the problems. And it doesn't mean that I can forget either about other more controversial areas. Obviously, if I go along to a group of homeopaths, for example, and I ask about the reliability of homeopathy, well, it's very difficult that the group of homeopaths says to me, homeopathy is not reliable. So it's not sufficient to ask experts and to ask communities of experts about reliability of their discipline or field, but once again, one has to demand empirical information about what it is that they're doing and that they are experts on. However, this is then the governmental situation. We have it. It was more or less defined, at least in Spain, in such a way that there's a whole market of court-appointed experts. Typically, when we talk about the expert market, literature and usually imagination takes us to the expert witness. But in the case of Spain, the market of experts is really a market of court-appointed experts and not only expert witnesses. And it's a scenario in Spain in which one depends a lot on the groups of experts, but in which these groups of experts are not demanded what should be demanded of them. So in this status quo, let's go to the next step, which is jurisdictional action. So we have the governmental action on the one hand. Let's see then how within those lists or catalogs that have been made that way, how is the expert chosen for a specific case? Well, every year in Spain, there is a draw and well, the draw is for the letters of the alphabetic list. So imagine if the draw will take place on January the 2nd, and if in that draw letter A comes up, well then the first court-appointed expert of the specialty or sub-specialty that the case requires will start by a surname beginning in A. So who in fact selects the court-appointed expert is just, well, chance or randomness. There is no genuine selection in Spain. What the judge does is simply sign the decree appointing the experts, and in this scenario, then, well, there has been the development, of course. Now we are living times of revolution of computer sciences. There are a number of computer tools. One of them is really interesting, and I can mention it. It belongs to the community of Valencia. It's a system that in Valencian language is called O Perit, something like the good expert. And through that system, there is governmental activity deployed. So the lists, catalogs, and information of the experts is there. Basically, the information of the lists is only the kind of official qualifications of the experts. But then what this computerized tool adds is that the system states directly who should be the court-appointed expert for that case. So the draw is not even necessary. It has to be done really for the letter, but in fact, the person appointing the expert now is not a person any longer, but rather the system. So the Spanish system, as we said at the beginning, is based on greater evidence value for the court-appointed expert on the basis of this impartial selection. Yes, yes, indeed. Fortune or luck makes or goes for this appointment of the expert to be impartial, but let me tell you, that's not the case necessarily, because if an expert has been appointed this way, this doesn't have to be impartial. We don't know whether the computer program, this Perit of Valencia, has any system saying, let's do it randomly. One should know more about the configuration of the computer system itself in order to know how it works, how the system works. So I don't know. Seeing the way things are, then, what are the incentives of participants in this practice? So what incentives would the parties and the judges and the experts themselves have to do anything with this situation? And the parties, we said that in the Spanish system, what has been anticipated is that parties, when they ask for expert evidence, they should ask that this expert evidence comes from a court-appointed expert and not choose them directly. But parties do ask for this kind of expertise. I thought I had empirical data on the slides, but I don't. And yes, there's quite a high percentage. I think it's about 25% in which the parties, yes, indeed, do ask for court-appointed experts. So then what would the incentive be in all this? What incentive could the parties have to having this system available, give up certain controls, even quality controls of experts, the jurisprudential criterion and judicial preference for this court-appointed expert? If judges are going to attribute greater probatory value to the court-appointed expert, necessarily, well, never mind what I spend as a party on money and other resources to appoint an expert witness, well, then my best strategy as a party will be to ask for a court-appointed expert and renounce or give up trying to, go through the controls that could be exerted over an expert witness that the party recruits. And about the judges, what's the main argument here at play? Well, the fact that they are impartial, yes. There are many opinions of judges regarding the current functioning of the system or concerning the system itself. And they say, well, it's an objective system. It's a system in which we are impartial, and that is guaranteed. Well, yes, of course, because you don't do anything. Right? The judge has been, well, they have no responsibility, no jurisdictional activity. Judges are not participating. So, of course, in that way, yeah, or if it's a decision that eventually depends on chance, well, then, yes, there's this judicial impartiality. Absolutely, it's guaranteed. But it would be guaranteed as well if they threw a coin into the air to decide who's going to be the court-appointed expert for that specific case. What about experts or expert witnesses? What are the incentives? Well, all to be followed. Position, because they are the ones that have all the control as to who is going to be part of the list. They have practically no negative incentives, so to speak. There is no anticipation, neither in the legislation or in jurisprudence. Well, the possibility that an expert is not allowed to be part of a list any longer because he or she carried out a bad expert job, or is not even a genuine expert in the discipline that he or she states he or she is. We could mention, for example, here the criminal code and think of possible sanctions that are established for experts that do their job badly. But even there, legislation and jurisprudence are really very demanding regarding experts in Spain. No, not demanding. Sorry, I changed it. Not demanding at all. In Spain, there is a case that I really think represents this very well indeed, in which the Supreme Court itself, well, one of the parties complained about the expert. The expert was a psychologist, and saying that the psychologist was going much beyond what she had to do in the report, much beyond the expertise or even the information the psychologist had to base the evidence on. And the Supreme Court eventually says there is no reason whatsoever to blame the expert because she is simply using her freedom of expression, her freedom of speech. So then there is no negative incentive here for experts in order to limit possible malpractice that sometimes happens with court-appointed experts.
Let's go back now to finish. Let's go back to the 3 points with which I started my speech, the 3 points that I was mentioning at the beginning, that is the differences that have been identified in order to give the highest probative value to a court-appointed expert compared to an expert witness. So the first was the impartial selection. Of course, if we are interested, or if we think it is a good strategy to have a list of experts available, then we need higher control of those lists. There are some or several initiatives, even at an European level, of big expert associations in which they say themselves and they suggest that a body is created for this control, for this role. So for this body to control not only the formal CV, so to say, of these experts, but also their experience, their behavior, how these experts have behaved in a general way in the procedural process when they have intervened in it. These kind of initiatives try to establish controls and empirical studies at a group level. So these are initiatives that can really be very fruitful. These are initiatives that, if we agree, we can have those lists, but then we need to take this activity as a governmental activity and take it very seriously. That is, we need to know who is part of this list, control who is in this list, and know what's the kind of training that these people have. That is, we need to really work on the quality and the methods used by different experts. Then there is another information that we could establish in this kind of lists, and I think I have already mentioned it, is to know what the experts have done when participating in particular cases. And there have been different activities in different parts of the world, in Chile, for instance. And some of the bodies has a kind of expert bank, and they ask users for their opinion. So they ask how the expert has behaved, whether he has been a good expert, whether he has, had the proper attitude also. And this kind of information can be very valuable in order to know what do really experts do, those experts participating in court, and to have general information about the techniques and methods that they are using. Now, this is a step. This is not solving everything in the probative value. We still need to know and to assess what the expert did in the particular case. And we need to assess also, I mean, if we want to go on those path, on that path of lists and controls, we need to know what the costs are, what the cost of those mechanisms would be for helping the judges. We cannot forget either that even when we have good lists of experts, let's think of an ideal in which we have a list with the best experts in that list, even in that case, when experts get to know the particular cases, we need to pay attention to cognitive biases, because maybe in the process of knowledge of those experts, maybe there might be, I don't know, errors or mistakes related to the particular work of the expert in that particular case. So even when having a solution, it's not the solution, the big solution. We can even need certain steps to improve the qualities of certain kind of evidences, because if we take really serious this kind of mechanisms, this can be very costly. The next point. The information that we give to the expert. And here I think that we have a key point that even though it's very elementary, we cannot just leave aside. What do we ask to experts in the particular case? We say that it's important to ask, to request, because the thing that I'm going to demand or to ask from the expert is very, very important. In the Spanish case, legislation is not helpful at all, because the court-appointed expert, when the judge is requesting for the expert, things cannot be changed. I mean, we cannot discuss, or the judge cannot discuss with the experts to know whether what has been set up is the particular thing to be requested for the particular case. Of course, there can be a communication in the Spanish case when the parties have asked for the judicial designation or nomination. So there is there, if you allow me to say, a perversity of the system, because we have a court-appointed expert, but the controls are controls by the party, not by the judge himself. So the parties pay and the parties contribute to establish those particulars. So it's not only a question of knowing what do we ask to experts, but to have the relevant information and to give that relevant information to the experts. And reforms right now are moving forward because they try to start any process with as much information as possible, with very complete information, allowing experts to have that full information to make their expert evidence and expert opinions. So in some legislations, you know, the discovery that has been translated into Spanish as descubrimiento probatorio, the discovery. So it's very important to have a very complete information from the beginning. And of course, that information will be key so that expert evidence improve and are better, because the expert will have as much information as possible. Then the payment, how payment is done to those experts, we can establish, and in fact we have established several controls for expert witness payment. For instance, the English system, there is a professor that has proposed and the reform we were talking about this morning, one of the proposals that has been done is that payments can be controlled, or that what experts will be paid is clear and transparent. How much parties have offered or have made to the experts. Of course, we can control the payment that has officially been made to expert, but we cannot control what has been paid extra-officially, and we cannot control when it's a court-appointed expert or when it's an expert witness. It's exactly the same case. Then the last point, how parties prepare. Parties do properly prepare experts in order to win the case. And of course, that's good. I mean, it's good that the parties really prepare the experts. They should go to court properly prepared, knowing the context, the judiciary context. But here, there is a very general statement according to the capacity that our judges have in order to rationally assess the knowledge of the experts. And when we talk about expert evidence, the question always is, are our experts able to assess the expert evidence? Yes, of course. And they are not only able to expert, but it's a must for them. If they are not able, then we need to have empirical evidence to show that lack of capacity. And if the conclusion is that they are not able, then we should just put aside those unable judges. In my opinion, instead of questioning once and again the capacity of our judges, we should need to look for procedural tools so that they are able to assess. Because of course they need to understand what the expert is saying, is stating and has signed in the particular case. The general information that I can obtain about the quality of the methods and the techniques used is one of the elements, but the judge needs to understand what the expert is doing with that method and that technique and how it has been used in the particular case. So I think that in that field there is much to do, and we can think on different tools that can really incentivize the understanding of our judges. The fact that in our systems we are so linked to this court-appointed expert, despite the system being so problematic as is in the Spanish case, has made that disagreements among experts has been considered a clear signal that one of the experts is being partial, while in fact there could be genuine disagreements among experts. So our systems, in front of disagreements, have tried to turn the thing upside down. And then we can have a third party, a third expert, as in the Spanish case, in which when there is disagreement between two experts, we just appoint a third one, as in, a football court, you decide 2-1. So we decide because there is a majority deciding, which is not rational at all. We should really look for mechanisms in order to try to learn something about that disagreement. What does this mean? It means that the judge needs to try to understand the disagreement. And in that case, we could have kind of assemblies or face-to-face meetings with the experts, as in the English case, with a report of the experts that disagree, explaining to the judge in what are they disagreeing. And in this way, it will be easier for the judge to understand the disagreement by the experts. We could even think, for instance, in meta experts. And what would those meta experts do when there is a very deep disagreement? between experts that meta-expert could train the judge about the disagreement. It could not be a case of introducing another expert opinion or further expert evidence, because, you know, that would not be the point, but to inform the judge about the particular disagreement. If the lack of understanding of the judge is because of a concept, because it's a very, you know, complex subject, we could even think, as it happens in the States, to have a technical advisor that could come before the expert evidence in order to inform the judge in a general way, so that the judge can then understand what the expert witness or the witnesses, or the experts that will participate in the case and will have a say in the case, in the case, can better understand what they are doing. Of course, we do not always need those tools. These tools can be exceptional, and sometimes we need them, but in other cases, it would be enough for the judges to be more proactive. In the adversarial case, asking experts about their doubts, when experts are stating something. So all these matters, all these tools, in order to compensate, so to say, or to incentivize or to foster the comprehension, the understanding of the judges. So I think that this would make it possible that there is not such a big important difference whether the expert is an expert witness or a court-appointed expert. So I think that the 4 points that you can see on the screen can be regulated in such a way that even though the 4 points are important, they can be important in order to take into account to rebuild the system that is regulating right now the expert evidence. And we should not base upon whether it's an expert witness or a court-appointed expert, but we should focus on what the experts are stating, and we should properly assess that kind of statements. So all in all, I think that those tools will lead to a rational practice and a much more rational use of the expert opinion than the big label of impartiality of the court-appointed expert, when we have not even cared about what is behind or what lies in things as the one that I have explained. Thank you.
Well, we're going to open the discussion session. We have approximately 30 minutes. Yes, hi, I'm Telmo Molina, criminal judge in Ecuador. So I have a question, not evidence, a question. Sorry, I said evidence, I meant a question. You talked about the in civil law, if I'm not mistaken, but I would like you to tell us things about evidence in criminal law in Spain, because in Ecuador, at least the way I see it, there is an overvaluation of the expert opinion versus the expert report, because in Ecuador, they actually admit the report without the expert actually having to go to court and express the opinion. I would like to know what the relationship is in Spain between the expert's report and the expert's witness in court, and what's the standard to assess the expert opinion on the basis of this, or expert evidence. Thank you. Yeah, the system that I mentioned is on the basis of, yes, the kind of civil side of things, but it has expanded to other branches. Although the origin was, yes, indeed, in the civil branch, there has been an expansion of the system to other branches. But of course, when one talks about experts circumstantially selected, in criminal law, what we do have in Spain is a greater incidence of expertise being carried out by public institutions, professionals, because in criminal law, many or much of the evidence, because of the type of offense, of course, or crime that is judged mostly in Spain, it has a lot to do with the task carried out by public institutions, and not so much, it doesn't have so much to do with the work of circumstantially appointed experts. What is the standard used for the assessment of expert evidence? Well, there isn't only one standard, really. Jurisprudence in Spain and also Spanish doctrine has identified lists that are increasingly larger of different criteria to attribute the probatory value to the expert opinions. So among those criteria, there are things like this. For example, whether the expert has been appointed by one of the parties, well, who gave the expert the information, what was the quality of the information given to the experts, and also, wait, I don't remember now what was the next. Yeah, anyway, the four criteria that I mentioned in my presentation are also used to give value to expert evidence. As I think that those are very important to assess the quality of expert evidence, well, then we shouldn't use them for assessing the expert opinion itself, but rather introduce it in the regulations in order to have a structural reform of expert evidence. Thank you, Professor Ricardo León Pastor from Peru. In my professional activity, I'm also part of arbitral courts. And in arbitration, as you know, there is one first advantage, and that is when there is the renounce of judicial competence. Well, the possibility is that the parties of the process select on the basis of the best criteria, and with experience in the case, well, the case of those professionals that will act in this arbitration. And the idea is that those people who sit there at the court are people who know about the business. Second, it's a completely private subject, so there are some few rules that if the arbitration is institutional. But my question is as follows. For you, if you can, to tell us more about it. What would happen if in this private framework in which everything kind of belongs to the parties, typically quite sophisticated, well, what would happen if one of the parties asked the arbitration tribunal or the arbitration court to appoint the expert, when we believe that in arbitration it has to be the parties that appoint the expert? So, but imagine if they asked for this court-appointed expert. So on the basis of your criterion, would this make it difficult for the court, for the arbitration court? Or could the court say, listen, you want that expert evidence? Well, get yourself an expert witness, and then we shall see if there's a conflict, then maybe there will be a court-appointed expert. Well, I think it has to do with regulations, right? We would have to read those rules regulating the activity to see whether that can be done or not. Concerning the effects on the impartiality and taking into account, well, this is anticipated by the system, but I think that, I don't think that there can necessarily be any impact on this judicial impartiality, because as is the case of any judicial decision, the judge has to be impartial, and that is a latency. One has to take care of this. But in my opinion, the way that one can best make sure that the judge is impartial, when you're asking the judge to assign the expert or appoint the expert, is always, of course, ensuring participation of the parties. The parties, for example, they themselves could present or submit a list of possible experts that they would agree on. And then among the list, well, then the member of the court could choose, when the lists have the full necessary information there in order to make the decision. What could be a possibility is that parties have the guarantee that if the judge eventually decides Luis will be the expert, and the parties know that that expert has some conflict of interest or some partiality somewhere, well, then that the parties have the chance to point out that happening. So I think there is this latency of the fact of the judges being impartial. It's there, but it's there in any judicial decision, really. And the way to guarantee that there is this impartiality doesn't mean to rob the decision away from who has to make decisions, but rather it lies in looking for mechanisms, in this case specific mechanisms through the parties and through the dialectic process between the judge and the parties, so that the parties can also adequately participate in that judicial decision.
Sí, doctora.
Yes, Dr. Emilio Alvarenga Córdoba, the Córdoba National University. I would like to tell you about another reality, which is the one of Córdoba in Argentina. Our country is federal. We have a provincial jurisdiction, 24 provinces, and a federal state. In Córdoba, local Córdoba, experts are appointed on the basis of a draw, and every party puts forward a controlled expert. At the federal level, it's the judge-appointed expert. But the problem, at least in the civil process that I'm going to be talking about, lies, it's a practical problem, and it's very difficult to find a solution to it, and it has to do precisely with the way these extra procedural payments, okay? I guess it's universal, isn't it? I mean, there's no solution to this. Why? Because you might create, and it does exist in Córdoba, we have a forensic organ of forensic experts, and when there is an official expert, both the official expert or the expert witness get the payment in order to write a report addressed to their party, so it favors their party. And I mean, that's a problem. I don't know, I don't see how you can really solve it, because in patrimonial cases, it can't be the state that has to appoint a whole forensic team to solve private circuit problems. So then to actually create, I don't know, a special expert group could be a possibility, but I mean, they eventually are court appointed, because if not, they are denounced, because they sometimes don't state things as they are. But I did want to highlight the fact that payment, extrajudicial payment, really harms expertise, and it makes it very difficult to continue with this impartial vision. I fully agree, as I said in my presentation. I think that any controls that can be established on the payments that take place, be it for the court-appointed expert or the expert witness, are, well, they're on one side, but what's extrajudicial is outside, and it's impossible to control. I fully agree. The microphone, please. But my question, here in the law that you mentioned, the Spanish law, it allows the litigant parties to put forward a consultant party expert. The Spanish civil law allows, yes, that parties put forward their own expert. As I said in my presentation, the LEC has anticipated a preference for the expert witness over and above the court-appointed expert, although we do find many situations, according to different procedural moments, in which, well, something else might happen. Good afternoon, Dr. César Proaño. I'm a judge in Peru. I do agree in that the Latin American reality is very different. There is a lot of weakness there in that we like expert opinion reports. To control extrajudicial payments is, yes, indeed, very difficult. But, for example, what would you think about in the judicial bodies in order to, every year, verify the task of these experts? So to have some kind of a questionnaire or a memorandum sent to all the judges of a higher court, verifying the actions of certain experts, because when sometimes there's some delay, some problems, things happening in different processes, it can be the judges themselves that assess what's happening. And that would be one of the requisites to be taken into account by professional associations and colleges. And don't you think in that direction too, that judicial power, well, should actually, as well as the controls established by professional colleges and associations, shouldn't there be internal control mechanisms for those lists to be part of the selection? In Peru, we have a selection process that's done by the judge with his or her own computer. But as you said in your presentation, all the other controls about quality of the expert, about the expertise or the goodwill of the expert are not really present anywhere. Thank you. Yes, absolutely. This kind of information is very important. And in fact, I have written about it. I think that it is information that is easy to have, easy to obtain, precisely on the basis of computer science nowadays. And it can be very relevant to have this kind of information. However, what I do think as well is that one has to be very, very careful about that information. And we cannot attribute consequences to experts only on the basis of the opinion of one of the judges. So then we would have to have greater control and also very well fine-tuned control to see how at some point in time, if we have a system of lists, we decide to exclude an expert from the lists and not allow this person to go back to the expert lists, or even go further and establish some kind of sanction for those experts who are not complying. So yes, indeed, yes, this is information, relevant information that can be obtained, that should be obtained, and with which there should be consequences for the experts that participate in the process.
Pablo Rapetti es mi nombre.
So, yes, I have a couple of minor questions. The first, I'm curious about historical understanding, so to speak. It has to do with which do you think are the reasons that have led to the fact that we are living times in which there is this, as you started saying, a kind of unfavorable situation, and when first court-appointed experts were kind of the elected, and now things have been changed and they tend to kind of favor the other, the expert witness. So why? The first hypothesis would be that yes, the problems that you mentioned exist, and they have led to wanting to change the model and move away from tradition. But then here comes the second question I have, and that has to do with what the intention is underlying your presentation. When you started your presentation, I thought that you were going to try and say something in favor of the expert witness, yeah, that's appointed by the parties. But what you told us about, and I mean, I don't know about this in depth, I think it's a problem that will also affect the system according which the preferred model is the expert witness. Because, for example, the lack of control over the quality of expertise per se is also a problem that is going to be equally affecting the expert witnesses and not only court-appointed experts. And then the idea that you have to resource, or you have to kind of look to the other side, as you said, to the expert associations or professional colleges, both intra and extradisciplinarily, that would be important as well to assess the quality of expert witnesses. So then I guess that first hypothesis to explain the change in the legislation is not really so kind of plausible or justifiable. And then on the basis of what you said later, I do understand that your intention is not to defend, really, the expert witness model, but rather to make the whole situation better. All the expert appointment system, whether it be court-appointed or on the basis of party appointment, never mind. But if this is then what you really want, well, I still think that the idea of potential greater impartiality in the appointment carried out by judges is there too, or still, because you said very clearly that one doesn't have to take this as the panacea. Absolutely. The fact that experts are appointed by judges and not by parties doesn't guarantee per se at all anything at all. But I would say, well, I haven't found in your presentation an argument that goes against the idea that potentially we can reasonably expect a greater degree of impartiality without this giving us any information about the eventual kind of technical qualities of the experts. But of course, regarding this maximization of controls that you put forward, compared to the optimization of mechanisms for judges to better control the appointed experts, I still think, at least, I mean, I haven't changed my opinion. I mean, on the basis of what you said, if this improvement of controls were achieved in a world better than the one we live in, well then, there will still be that greater potential of being impartial when there is a court appointment and not a party appointment. Except in the case that you want to add something to counteract. Thank you, Pablo. Well, the historical reasons of the change, I think, come from different places. Because some of the lines or schools of thought have had to do with the difficulties entailed by managing a system like this. Because if you take it seriously, it's a system that is really painstaking and requires a lot of money. Because of those problems, it was all too big and too heavy. Well, the decision was made of saying, well, let's go for expert witnesses. Let's get the parties to select their own expert. Then there's also another school of thought in this, and in my opinion, it explains the legal changes, at least in some latitudes, that have been done to get rid of the court-appointed expert, and that has been the idea of a more adversarial system where the parts have more information, and especially the expert procedure itself. There is quite a strong argument there incentivating or moving for change in a more adversarial line, yes? So doing away with those institutions that traditionally have been considered as more typical of inquisitorial systems. So at least these arguments historically, yes, I can put forward. Then the lack of intention. Thank you for your question, because maybe I wasn't clear enough in my presentation. Because listen, I think that you are posing the question really kind of as an opponent, but I totally agree with what you say about the different levels of what you just said. The basic idea of my paper, of my work is, if we assume, as traditionally the assumption has been, that the impartial stance of an expert lies on the way he or she has been selected, and this is going to have an impact on the quality of their task, and then on the judicial assessment of that, well, everything is wrong. But if we don't assume that fact of it all being impartial in the way they are appointed will have an effect on the quality of their work, and will not have any consequences on the judicial appointment itself, well, then we would have to see what the limits are, or what the consequences are that I could obtain that could come from a system like this. I think that in a system like this, and when I was saying if we consider it adequate to have lists of experts, I was referring precisely to issues like this, in which I believe that one of the possible positive aspects that we could still preserve with these lists of experts is the control over the quality of the methods and techniques that these experts use. And so we would be able to exclude from those lists, for example, certain areas of knowledge or disciplines that are problematic or that have not proven themselves to be at a level that we believe adequate regarding reliability and solidity. But if this then is the positive aspect that those expert lists could have, and then that judicial control regarding being in harmony with the expert communities, well, then I would say it's useful both for the expert witness as for the court-appointed expert. There is no difference. And I see it the same with the other elements such as payment. So what information is given to the expert for he or she to carry out the expert evidence report? Well, all that, the preparation of the parties and so on. I think that, well, you have the same problems when it's a court-appointed expert or when it's an expert witness. And the interest for everyone, for both types of experts, is how do we regulate? What are, I mean, instead of talking, for example, of generic, yes, of the impartiality of any expert and the judge, well, it would be good to establish clearly what the duties are, very clearly, what the duties and even the skills and capabilities of the experts regarding the judges. And here, once again, let me mention the English system in which, in order to establish the extremes of expertise and in order to gather all the relevant information that the expert should have in order to carry out his or her expert opinion, he or she can ask for a meeting with the judge and can tell the judge what the doubts are that this person has before starting any expert procedure. So in these systems, you have criteria by which you are told, well, listen, the expert report of the expert witness depended on what the parties said to him. Well, fine, but I mean, regulations haven't even anticipated the possibility that parties can ask this from the judge. And that's why in that line of thought, well, there's the idea. Let's modify the system on the basis of these three issues that we believe are really, really relevant.
7 people have asked the floor. Unfortunately, we only have 5 more minutes. So I don't know whether there will be someone generous enough to just give up their time, but I will ask you to be very, very brief, and we will try to collect all the questions and go for the answers then on a row. I'll try to be concise, precise, and to the point. I come from Mexico, the Autonomous University. I thank you very much for your speech, because I think that touching the standard of proof and the expert evidence is key, especially for judges. And the scheme that you have explained us about the civil procedural law is very much like the same law in Mexico. And my question would be the following. Even though you have mentioned that your proposal or your major concern in your presentation is to state the need to have a rational and impartial statement of the expert evidence by the judge, taking into account different factors. And your starting point is that these factors have a lot to do with how experts have been appointed. And I see many problems, because I do coincide that it's not only how experts have been nominated, because problems can appear both in expert witness and court appointed experts. In Mexico, we try to solve the thing with an exam in order to include experts in the list with very clear tests and exams. But I would like to know your opinion. I think that you said somehow in your opinion that apart from having credentials and the attitude of experts in order to assess a participation in a trial, also techniques and methods used should be taken into account. But how can a judge assess methods and techniques when his or her major responsibility is to assess, but he does not know the test? I mean, he does not know the expert evidence, because the judge do not know them. So that's why he tries. Excuse me, but I need to ask you to be briefer. Sorry. Okay, I think that's clear. Thank you. Pere Matei from the University of Girona. There is something in particular that I like very much. You have the idea to give the judges, you have to be much more involved in the expert evidence. I mean, try to be involved in the knowledge, and when you will be involved, you will better understand. But there is something about which I'm a little bit more concerned, because there is always a point in which, even among experts, the knowledge or the debate is quite deep. Let's imagine that in an expertise, we are in a debate whether norms or rules are ethics or expressives, and we ask the judge to be involved in the subject, and then we call another expert. Would you go for the electic part? Or maybe we could even have another expert saying, well, this distinction has no sense at all. Then what can the judge do? That's a problem for me. So what would you do in that case? I really think we do not have time for the rest of the questions. So we are going to finish with the answer of the speaker to these previous questions. Thank you, and sorry. Soraya, I have an idea of judges which is different from yours, I believe. Our professional judges are deciding cases all the time, and I do not believe that our judges do not know techniques and methods that are usually present in a trial. Along the same lines, I think that training should improve about those techniques and methods being used on trials. I mean, it's not enough for judges to just follow law courses and not to take courses in general courses about genetic evidence, for instance, that are very much in court. So when we talk about expert evidence, we need to know that we do not have problems with any kind of knowledge. I mean, expert evidence are very concrete, precise, concise, and to the point in particular subjects, and we need to focus on them. And the judge has to assess what they do and they say for a particular case. According to the reliability of methods and techniques, I think that we need to foster the bridges with communities of experts, because only those communities can do the necessary research in order to tell us what's the reliability of what experts do and use in particular. Pere, about disagreements between experts. Of course, if you have a disagreement between, I mean, in a particular field of knowledge, in particular, for instance, in psychology, to choose an expert on a field will determine how the case will be solved. That is why it is important to allow for the presentation of expert evidence to the parties, because then we can introduce in the process the other point of view. When there is this kind of disagreements in the judiciary process, in the trial, we do not need to flee from them, but we need to try to get information about them so that we can give more importance to an expert opinion or to the other. If, despite all efforts, because the judge is not an expert and will not be able to solve a disagreement of that kind, then either he has got other evidence to solve the case, or he has the burden of the evidence.
Muchas gracias.
Thank you.